and thank you for joining us today. My name is Yongki Hong, and I'm a Senior Associate at Sky Legal PC. Today's webinar will focus on how to move from a non-immigrant visa to a green card in the United States. We are very fortunate to have our firm's managing partner, Ian Scott, as the speaker for today's presentation. I will begin some overview and introductions, and Ian will discuss more detailed and practical guidance on a lot more important matters. Before we dive in, let me briefly introduce our firm and go over a few housekeeping items. We are a full-service immigration law firm, and we offer representation across a wide range of practice areas, including E201, TN, H1B, all types of employment and family-based green card cases. That said, we are particularly well known for our work in complicated green card cases, and we have built a strong reputation throughout comprehensive approaches and strategies. Okay, we have processed thousands of these green card cases and have been able to secure approvals for the vast majority of them. At the end of this webinar, we'll send you several useful tools. A copy of the PowerPoint presentation we'll go through today, a link where you can download the guidelines with more details on visa options, a link to sign up for additional webinars, a link to webinar recording on YouTube. We encourage you to subscribe and hit the notification button as we regularly post immigration related videos. And finally, a link where you can set up a private consultation with our team. Finally, for any questions, please type them into chat box or Q&A box. We'll discuss all the questions at the end of presentation. With that, let's get started.
Great, thank you very much, Yongki. And let me start out by just talking a little bit about the way that the green card system works in the United States. So in the United States, the way the system works is quite a bit different from other countries, because in other countries, they may have a points-based system or something like that, where if someone accumulates points based on the speaking the language, education, work experience, etc., after they get a certain number of points, they may qualify for permanent residency. But in the United States, there's just a system where there are a list of green card categories, and if you're eligible, you can apply. So these are generally broken up into family-based and employment-based categories, and the family-based categories are further subdivided into immediate relative and preference categories. And the big difference between those is really that the preference-based categories typically have quite a weight associated with them in terms of waiting to get the green card, whereas the immediate relative category, for example, if you marry a US citizen, then that's going to be a lot faster process. And then the employment-based categories are broken down into EB1 through EB5, and we're going to talk about each of those in detail. The only one we're not going to talk much about is, or at all about really, is the EB4 category, which is a religious-based green card. So first, let's talk about the family-based, and we touched on this in the intro. And if the immediate relative category, there are really two main categories here, where it's someone is marrying a U.S. citizen, or if there's a U.S. citizen child over 21 that is sponsoring a parent. Now, the benefit of the immediate relative categories is that there's no wait there, so the green card is always available. So because the way that the green card system works is that the government issues a certain number of green cards by category, by country, and then once they reach that limit, the people go they go into a queue or in a line. Now, the immediate relative categories, in contrast, though, they don't have any line. So those ones are always going to be available, so there's never going to be a wait associated with them. Now, the preference-based categories, for example, would be something like a U.S. citizen brother or sister that's sponsoring somebody. Now, just to give you an idea of how long this wait can be, that particular category has around a 15-year wait. So it is quite an extensive wait. So for all intents and purposes, it really isn't even a practical category, because who wants to wait around 15 years for a green card to be available. Somebody's plans may have changed, etc. So, but this is a very popular way, or the family-based categories are a very popular way for people to obtain green cards in the U.S. So it could be somebody's on an E2 and then they marry a U.S. citizen, or it could be that someone is on an E2 or a TN or an H-1B, and then family member had sponsored them a few years back, and then their priority date becomes current, and then they get a green card. So a very popular way to get a green card in the U.S. And for all of the green card categories, once you get through the procedural part, so if let's say you're marrying a US citizen, the procedural part would be proving that it's a bona fide marriage. Once you get through that, you're always going to, the process is either going to be a two-step or a three-step process. So the first step is going to be the procedural objective part. And then the second part is going to be the obtaining the green card either through adjustment of status process. So that's going to be somebody that's in the United States or through consular processing. So regardless of which green card category we're talking about, everyone is going to go through one of these two steps: consular processing, which occurs in the home country at a consulate, or adjustment status, which is the process for obtaining the green card in the United States. So the moving on to the employment-based categories, we have the first one that we're going to talk about, which is the EB1A extraordinary ability. And you'll see a list of 8 criteria listed here on the page. And what has to happen is that the individual has to meet at least 3 of these. Now, in the past, what happened as well is they had to meet 3 of these, and then the government would take another kind of subjective look to make sure that the person had risen to the top of their field. But the courts just recently struck down that second subjective look piece. And now if you meet 3 of these, so if you are, judging the work of others, if you have high salary and you have a leader critical role in a distinguished organization, then you are entitled to the green card. And what we see typically here is that these criterion are all really getting at showing, or a mechanism of trying to show that the person has risen to the very top of their field. So if someone's paid a very high salary, could mean that they have risen to the top of their field. If they're judging the work of others, when you look at American Idol or something like that, and the judges are all going to be accomplished singers and performers, so they've made it to the top of their field. So really they're looking at, if you've hit 3 of these, then that's where you're going to be able to get the green card. And what we tend to see is that people who are coming under this category typically had an O1 before. So the O1 criteria, O1A in particular, are very similar to the EB1A criteria. So that's something that usually when we see people applying for or moving to a green card, they're moving from an O1A. The next one that we're going to look at is EB2 national interest waiver. Now, this falls under the EB2 category. As I mentioned at the beginning, the categories go EB1 through EB5. Now, EB2 is broken out into 2 different pieces: EB2 national interest waiver and EB2 perm. So this time we're just going to talk about the national interest waiver. And what this category is really saying is that the individual is coming to the United States to do something. And they're coming to do something which is, so we'll call that their endeavor. And the endeavor that they're coming to the United States to do, that has to be in the national interest. In order to get this green card, the endeavor has to be within the national interest. So something that the United States feels is very important and that they want to give the person a green card because that person's coming to the United States to do something very important. So it could be that the endeavor is going to create jobs or have some significant economic impact. It could be that the person's invented something, a new technology or a new methodology, anything like that. But it is a very high bar. And then the person also has to be well positioned to advance the endeavor. So we look at educational experience, maybe their track record. Have they done something like this before? And then the final thing is that you have to show evidence of why the government should waive the labor certification, because typically what happens is the government says that it's in the national interest to protect US jobs. So you have to show that what you are doing, what the person is coming to the United States to do, is more important than that thing that has already been identified as in the national interest. And then for NIW and all of EB2 really, there are threshold criteria where you have to have either an advanced degree, which is a master's or higher, or a bachelor's plus 5 years, or exceptional ability. So the both of these, the EB1A and the EB2 national interest waiver, the good thing about both of these is that they do allow you to self-petition. So they you don't need an employer, so that's a great part of these two. And these are both going to be two-step processes. We talked about the two or three-step process before. When we were going back to the going back to the family base, look, let's say someone's marrying a U.S. citizen. The first part of the process is going to be the I-130. The second part is going to be the I-485 or the consular processing. But then when the person has the green card, there is a third part of that process where there's a removal of conditions. And we'll see that in the employment-based context as well. But for EB2 and EB1A, there's only a two-step process. So that's the first part, which I'll call the hard part, of proving either that your endeavor is in the national interest or that you have risen to the top of your field. But then the second part is going to be the I-485 or the consular processing. And if you are in the United States and doing the I-485, you can file work authorization and travel authorization when you file. Now, the next way that many people move to a green card is, just going back to the EB2 national interest waiver, we see a lot of people that come in initially on E2 and move to a national interest waiver. They may, for example, have started a business where they are creating US jobs, and that could be one mechanism. The business they could have started may have been cyber computer consulting or something, or developed a new technology. It could be a tech startup, and that could be in the national interest. So that E2 is a kind of a lot of our clients. That's how we move them to a green card. Um, Now, EB2, EB3 perm, that is a significant way that a lot of people move to a green card. And typically, these people are people on a TN visa, H1B visa, maybe even an L1 visa. And this is just the traditional company sponsoring you for a green card. So this is, a way that a large number of people move to a green card in the United States. And this one is going to be a three-step process where the first step is going to be with the Department of Labor. So that's proving that you can't find a qualified U.S. worker. The second is going to be an immigration process of filing the I-140. And then once that is done, you're going to file the I-485 or do consular processing. But usually for perm, it's going to be the I-485 because usually the person is in the United States already working for the company. It doesn't have to be that way, but usually that's the way that it is. So I said we're not going to talk about EB4, which is the religious-based visa, but we'll talk about EB5 because this is another way that a large number of people move to a green card in the United States, and that is investing. So that's going to be investing either 800,000 or 1,050,000 in a new commercial enterprise in the United States. And once that money has been invested, then it could be a direct investment where you're starting your own business, or it also could be that you're investing in something called a regional center. The regional center is typically a more passive form of this investment, whereas we see people with E2s, not so much, but we see people with H1Bs or other types of visas moving towards this. Even they may have a B1, B2, and they're moving towards a regional center because they want some passive form of investment. Or it could be someone that's on an E2 that's already invested money in the United States and now wants to further invest and get a green card. And then that person wants control over their own destiny, the profits, the hiring, etc. And so they do that. So the other key part, other than the investment amount, which is 800,000 or 1,050,000, is that the business has to create 10 full-time jobs. And we typically, whether it's a regional center or direct investment, there's going to be a detailed business plan, and the jobs have to be linked to the investment that you actually have made. And so this is a three-step process where you're going to do the I-526, which is the first part of the process, and 485 for the consular process, or 485 for consular processing. And then after you've had the green card for 2 years, you have to do the I-829, which is going to be the removal of conditions. So showing that you've actually created the 10 full-time jobs. Some other green card options are diversity lottery. That's happens every year. So they pick 50,000 or so green cards. And then there's some humanitarian-based green cards like victims against domestic violence and people helping police solve a crime. And then, of course, we're always looking for possibilities for immigration reform. The other things that you always have to keep in mind is timing, because if you're doing something like EB5, EB5 is going to take a long time to be ultimately approved. So you do have to make sure that you're maintaining some underlying status, and that's going to be important to make sure that the idea is to continue living and working in the United States, that you're maintaining some underlying status so that you are able to do that. So whether it's on TN, H-1B or whatever, and also that if you do have to travel, you're going to need to have some type of travel authorization. If you have a 485 pending, you have to have some type of travel authorization. And your visa may not be a dual intent visa, so that's something that you have to keep in mind. If it's not a dual intent visa, then you have to be very careful when you enter the United States, if you do get status or move towards a green card, and you have to do that carefully and really in conjunction with the immigration attorney. And people often do have parallel strategies. Sometimes you'll do an EB-5 case for somebody, and then they might marry a U.S. citizen, then you change it over to that, and so those all can work really with. And I think that the key really is that things are planned well. Well, that is all the prepared comments that I have, and I'll turn it over to Yonki to ask if there are any questions, and we'd be happy to answer them.
Yeah, that was a really great presentation. Thank you, Ian. If you guys have any questions, please type them into box. Great. If you don't have any
Mhm.
questions, you can also schedule any private consultation with us when you have any other questions, and we will send you the emails with the links that you can set up the consultation. So you can also register for the next webinar, and you can follow both. So thank you for joining us, and thank you for the presentation. Yeah, thank you.
Great,
Bye.
thank you very much. Thank you. Bye bye.